All right, hi everyone. I think we're going to go ahead and get things started. And I am Dean Anita Krug, Dean of Chicago-Kent College of Law, and it is wonderful to see all of you here today, to welcome all of you to our annual Palmer Lecture to honor this year's recipient of the Chicago-Kent Roy C. Palmer Civil Liberties Prize. The Palmer Prize was established in 2007, so about 15 years ago, by Chicago-Kent alumnus Roy C. Palmer and his wife, Susan M. Palmer, to honor exemplary works of scholarship that explore the tension between civil liberties and national security in contemporary American society. Roy Palmer was a lawyer and a real estate developer, a 1962 honors graduate of Chicago-Kent, and a member of Chicago-Kent's Board of Advisors. In 2012, he received the Chicago-Kent Alumni Association's Distinguished Service Award, and in 2013, he was named one of our 125 alumni of distinction in connection with our celebration in 2013. Before his death in 2017, he and Mrs. Palmer were active in numerous civic, social, and philanthropic organizations. I want to welcome today Roy's daughter, Heather, who seated in our second row there. Welcome, Heather. And Susan Palmer was unfortunately not able to attend this year. She's usually a regular to these events, and so we're sorry not to see her this year. And today, joining us on our list of distinguished scholars who have won the Palmer Prize in past years is Jens David Ohlin, the Alan R. Tesler Dean of Cornell Law School. We are honoring Dean Ohlin for his book, Election Interference, International Law and the Future of Democracy. This was published by Cambridge University Press in 2020. Dean Ohlin's scholarly work stands at the intersection of criminal law, criminal procedure, public international law, and the laws of war. His research has addressed questions ranging from criminal conspiracy and the punishment of collective criminal action, to the philosophical foundations of international law, to the role of new technologies in warfare, including cyber war, remotely piloted drones, and autonomous weapons. In addition, Dean Ohlin is the author of 3 case books in 3 different fields, namely international law, and criminal procedure, and he is the co-editor of the Oxford series in ethics, national security, and the rule of law, a steering board member of an international working group researching secondary liability for international crimes, and a member of the Council on Foreign Relations. Dean Ohlin graduated from Columbia Law School and holds a number of other degrees, including 2 master's degrees and a PhD degree from Columbia University. And with that, I welcome Dean Ohlin to the stage.
So thank you very much, Anita. I really appreciate those warm words of welcome. And let me just say how incredibly honored I am to be here, to receive the Palmer Prize, to visit this great law school, to meet with your students and faculty today. I had a wonderful session with students this morning and found them to be engaged and brilliant and with such bright careers as lawyers ahead of them. So today, I'd love to talk with you a little bit about the subject of my book, Election Interference, and I'll take you through, I hope, some of the inspiration behind the topic, how I got into it, outline my particular theory that I developed in the book, and then talk a little bit about some of the practical consequences of the legal analysis. And then I'd really welcome the opportunity to hear questions and comments and criticisms if you have them, and we can have a nice discussion at the end of the session. So how did I get interested in election interference? And What was the inspiration for doing the book? Well, it's very much a product of its time, 2016. The election in 2016 was obviously a very stressful event for the whole nation. And from my perspective, one of the things that was a significant development was the role that Russia played as a foreign actor. And in particular, it wasn't just that the Russian government was allegedly involved in the election, because quite frankly, there have been many instances where foreign governments have intervened in an election, expressed a point of view on the outcome of an election, interfered in political matters in another state, whether covertly or overtly. None of that is new. But from my perspective, what was striking about the 2016 election was the allegation that the Russians were operating troll farms in St. Petersburg, that these were operated at the behest of the Russian government, and that the Russian government was using social media firms to spread disinformation, and that the troll farm posts were communicated in such a way as to pretend to be authored by Americans, even though they were by Russians. So it was sort of harnessing the power of social media platforms, but not doing it in an overt way, doing it in a covert way, pretending to be Americans to enter into the discourse of our political system. So the question that I immediately started asking myself was, is this a violation of international law, first and foremost? Can we criticize Russia for this behavior? And when I started thinking about it and researching the topic, I immediately started seeing that the international legal community was very much divided on this point. And there were lawyers who thought it was a violation of international law, Russia was doing, and there were lawyers who thought it was not a violation of international law. But from my perspective, I felt like the discourse was problematic, that there was an element to the discourse that was entirely missing. And I felt even if I agreed with what the lawyers were saying in terms of it being a violation of international law, I felt like they had the wrong reason for saying that it was a violation, that it was illegal. So a major contribution to or a major contribution that I was trying to make to the literature was to outline two particular arguments that I was reading in the literature and reading in the public discourse that I thought were misplaced. What are those? The first is the argument that Russian interference in the election constituted an act of war, that it was a form of cyber war, and cyber war violates international law. So that was the first argument, and I want to talk a little bit about why I think that argument doesn't really work as a plausible framework for analyzing the situation. The second argument that was frequently heard was that what Russia had done was a violation of US sovereignty. So it was a violation of a principle of non-intervention, that we should not intervene against the sovereignty of other countries. I also thought for particular reasons that that argument was misplaced as well. And so I proposed an alternative framework, which was the framework of self-determination. And I can go through what my reasons are for rejecting the first two paradigms and proposing this third alternate paradigm of self-determination. And then I want to talk a little bit about some of the consequence of adopting this alternative paradigm, like what flows from it for purposes of the legal analysis. So let's take the first one, cyber war. At first glance, it's incredibly intuitive. It sounds good because what Russia was doing was using cyber technologies. And we know that military conflict is no longer limited to kinetic attacks on the battlefield, that modern militaries use cyber weapons all of the time. I mean, we have an entire cyber defense command as part of the US government to fight battles using cyberspace. So there's no question that cyber attacks and cyber war is not just something of the future, but something of today. But on the other hand, the language of cyber war doesn't graft very easily onto the situation foreign election interference through social media firms. And it wasn't just legal scholars who were toying with this idea that it was a cyber war or a cyber attack. It was also American politicians who were describing what the Russians had done using the language of a cyber attack. It was a cyber attack against this country. The problem with using this framework is that there are very technical requirements for when a cyber attack can be considered an act of war or an act of warfare under international law. And the standards usually revolve around some kind of tangible consequence which involves destruction or disabling either a tangible object, an installation, or loss of life and limb to individual human beings. In other words, international law is entirely comfortable with saying that a cyber attack can constitute an act of cyber war if there is some destructive consequence to the cyber attack in the same way that a kinetic bomb would produce a kinetic loss of life or destruction. So if you use a cyber weapon to blow up a building, that is a violation or is regulated by international law just as if you had dropped a regular bomb on a building. Similarly, if you use a cyber weapon to either kill or injure a human being, that's regulated by the laws of war in just the same way that if you had shot someone with a bullet in an armed conflict, that would be regulated by international law. The problem, of course, is that what was destructive about the Russian election interference had nothing to do with any kind of destruction of a facility, loss of life to an individual human being. To the extent that there was something troublesome about Russia's interference, it wasn't that. It had nothing to do with destruction. So the whole language of cyber war and how it's regulated on international law just seemed inapplicable to this particular harm. And perhaps you say, well, okay, election interference then isn't regulated by international law at all. Maybe that's the outcome of the analysis if it doesn't qualify as a cyber war. But I think that's a little bit too quick of a conclusion. You have to go through all of the other alternative paradigms and find if there is an alternative that maybe matches onto the situation a little bit more comfortably. Okay, so that takes us to the second paradigm, sovereignty and the principle of non-intervention. Okay, just to back up for a second under international law, what do lawyers mean when they talk about sovereignty and about non-intervention? Every country in the world has legal personality, and what goes along with their legal personality is a bundle of rights associated with sovereignty that includes not just the right to exist as a nation on the world stage, the right to engage in relations with other states and form treaties and engage in diplomatic negotiations, but it also entails a right to run one's own domestic affairs free from a certain amount of outside intervention and interference. Now, what constitutes an illegal intervention or a sort of meddling in another state's sovereignty is a little bit complicated because, of course, states are always acting on the world stage in ways that have consequences for other nations and the lives of their subjects and their citizens. Just because something we do here has an impact on life in another nation doesn't obviously make that a violation of another state's sovereignty. If it did, then almost everything would be a violation of the intervention principle, and it would be pushed to the point of absurdity. So whatever sovereignty and the prohibition on intervention or the principle of non-intervention mean, it doesn't simply mean that there is a consequence to the life of another state. So how do international lawyers distinguish between a prohibited intervention and a permissible one in terms of another state's sovereignty? Well, there are, again, technical rules under international law which prevent us from concluding that an election interference, at least of the type that Russia engaged in 2016, violates the principle of sovereignty. And in particular, the legal constraint that I would highlight now is the requirement that the intervention have some kind of coercive aspect. That's not the only legal route, but it's the primary one by which you can declare something to be an illegal intervention. There has to be some kind of coercive aspect to the behavior. Just sort of, take an example in the famous Nicaragua case that was resolved by the World Court in 1986, a dispute between Nicaragua and the United States. There was a claim that the United States had mined the harbors and prevented ships from getting to Nicaragua, and were trying to coerce a particular outcome out of Nicaragua, and were using the deployment of mines in the harbor in order to achieve that particular, get them to pursue a different course of action. That element of coercion really is a problem for the election interference case here, because as much as I tried to sort of think through, well, what exactly was coercive about it? Who was doing the coercing? Who was being coerced? And what action were they being told to take? And what consequence was being imposed on them if they didn't follow through? It just doesn't really work, that description of the state of affairs. So unfortunately, even though politicians were running around saying that Russia had violated US sovereignty by meddling in the election, as a legal construct, sovereignty turns out to be surprisingly inapplicable to the situation. So that's where most scholars, most practitioners, most diplomats would then end the analysis and say, okay, we can all go home. This is probably not a violation of international law. It's certainly troublesome, it's certainly concerning, but international lawyers, you can sit down now, you have nothing more to say about the subject. And I think my intervention of my own, my scholarly intervention, was to say, not so fast, there are other legal frameworks that we can bring to bear on the discussion. And the primary one that I wanted to talk about in this book is the concept of self-determination. And the framework that I proposed was to say that Russia had violated the American people's right of self-determination, and that in a democratic system, in a democratic country, the right of self-determination plays out or is actualized through the machinery of a democratic election. States obviously have different ways of expressing their self-determination, but in a democracy, the way we express our self-determination is by selecting our own destiny, and we do that through the form of an election, and then decide who our leaders will be and confer upon them political authority to make decisions on our behalf. So that's the right of self-determination, and I believe wholeheartedly that the particular harm associated with Russia's meddling in the 2016 election was that it interfered in that collective right, that right of the American people to determine their own fate, which is protected under international law under this rubric of self-determination. It's not something that's just made up. It's in the UN Charter, the collective right of self-determination. It's also codified in the International Covenant on Civil and Political Rights. It's also referred to in the International Covenant on Economic, Social, and Cultural Rights. So these very foundational documents, these treaties that underlie the international legal system, explicitly make reference to the right of self-determination. And every legal scholar recognizes that the collective right of self-determination is among the most core pillars of the international legal system. Well, given what I've just said about the centrality of self-determination, why then were scholars and practitioners not rushing to the language of self-determination to analyze election interference? And my answer to that is that the right of self-determination has the status almost as a bit of an orphaned right under international law. It's universally recognized as being a central pillar of the legal system. Every international lawyer recognizes that all peoples have the right of self-determination. and yet lawyers hate to actually use this concept in legal arguments. They would rather deploy other legal tools at their disposal and would rather confine self-determination to the back burner, perhaps to the confines of history, and not actually use it in their legal arguments. One of the reasons I think that international lawyers do that is because they find the concept of self-determination to be frustratingly vague, somewhat inchoate, and hard to grasp, because in part the right of self-determination attaches to peoples. So countries don't have self-determination per se. It's a people that have the right of self-determination, and that gives rise to the right to secession in some cases. It gives them the right to either have their own state or to participate in another state if they freely wish to participate in another state. And it attaches to this notion of peoples. And I think lawyers can't stand talking about peoples, quite frankly, because it sounds like something that an anthropologist or a sociologist or a historian should talk about it. It's like, we're lawyers here, we deal with precise legal concepts, and if you want to talk about your vague, fuzzy things, go across the quad to one of the social sciences or humanities departments, and you can play with your peoples and your self-determination. And I really think that that's an important dynamic at play, because if you're an international lawyer, there are very strict criteria by which you determine whether or not something is a state or not. And in fact, in uncontroversial cases, you just go to the United Nations and you look at the seats and you see if there's a placard there and whether or not there's any, well, that's a state. It's very easy to figure out whether or not there's a state there. But deciding whether or not this particular entity is a people and whether or not they are owed the right of self-determination, man, you got to start fighting about all sorts of complicated stuff. Language, history, religion, ethnic ties. I mean, that's really messy, sticky stuff. So I think lawyers have tended to avoid it, but I think they avoid it at their peril, because there are some situations where the concept of a people is really a core foundation and you can't lawyer your way around it. The concept of genocide is one good example of that, right? Peoples are owed a right to be free from genocide, and you can't simply avoid the topic if you want to talk about the legal protection of genocide. And so too, I think, in the context of election interference, what Russia did was a violation of the collective right of self-determination for the US population. That also has some very tangible consequences, and that's what I'd like to pivot to next and talk a little bit about. This is more than just an abstract argument. I think it ends up structuring the legal analysis once you recognize that self-determination is important and that it entails a right for a political entity to protect itself from outside interference in the conduct of its elections and the machinery of its democracy. So, in what way are there these practical consequences? Well, if you think a little bit about the democratic system and how we go about implementing the democratic system, we have all of these very technical requirements which determine who can participate in our election system, in the political system, and in what way. If you're an election lawyer, you'll spend, you spend your entire career, either enforcing or, defending allegations, and those rules can be quite complicated. But if you boil them down to their most essential, core part, what those regulations do is draw a bright line between insiders and outsiders. So the rule, for example, in this country is that if you want to vote in a federal election, you have to be a citizen, and non-citizens are not allowed to vote in an election. Similarly, if you want to contribute financially to a candidate, or even if you want to spend money on a particular candidate on your own behalf, but you want to support a candidate by spending money in an election, you have got to be a U.S. citizen. So the rule is that foreigners are not entitled to participate in U.S. elections, either by voting in the election or by spending money on the election. And it's interesting to think for a second about why we have that rule. It's not just an arbitrary rule, but it's very much connected to this conceptual foundation that I've tried to outline here today, which is the right of self-determination. If we allowed outsiders to participate in a meaningful way in a federal election, whether by voting or by spending money on behalf of a candidate, the results of the election would stop being an expression of the will of the American people. It would start being an expression of someone else. And that's the whole reason why, if you're off in Sweden and you're a Swedish citizen, you have your own elections you can participate in. And I'm picking on Sweden because my dad's a Swede, so it's kind of an inside joke here. I don't mean to offend anyone who's Swedish in the audience. But the point is, you don't get to participate in a U.S. election. And there can be, I think, meaningful and legitimate debates about where exactly to draw that line between an insider and outsider in terms of the American polity. For example, I think there's a very colorable argument that the line should be drawn in such a way that permanent residents, right, should be allowed to vote and participate in an election. So it's not just citizens, but also permanent residents who have made a particular commitment to this location, who are participating in the polity in a meaningful way. But even though there's people who will have that fight and disagreement over permanent residents, there's no one who I think has a serious, good argument that people all the way in Russia should be participating in our elections. So what a country does, what a democratic country do, is they enforce through these boundary regulations participation in the political system. And what gives us the right to do that is our collective right of self-determination, our need to select our own destiny. And all peoples have that right. Just to give a third last example of that type of boundary regulation, and this one's a little bit more obscure, but there's something called the Foreign Agent Registration Act, FARA, and it basically means that if an individual is acting on behalf of a foreign power in the United States, pursuing the interests of a foreign government, whether it's Russia or Canada or Saudi Arabia or Britain or France, it doesn't matter what country, but if you are acting on behalf of that foreign power, you are supposed to register with the federal government, so it's known to the population that you're acting in this way. And I think, again, it's a requirement that if you're going to be participating here at all, you have to do so in accordance with particular rules, and we have every right to impose those restrictions and those rules on those foreign actors attempting to influence our political process in a particular way. So when you take all of this together and you think about the self-determination and you think about the boundary regulations that we have and the way we protect our democracy in this way, the question arises, what can we do about social media disinformation? Is there a way that international law can authorize us to use tools at our disposal to respond to this violation of international law in the form of election interference? And I think the time is now to consider an important potential criticism or complaint, which is that even if we have a right of self-determination and that another state violates international law by interfering in our elections, that we have to be very careful about what we do in response, because the First Amendment and freedom of speech really limit our capacity to deal with misinformation and disinformation on social media platforms. And I think this is a part of the argument which very much dovetails with the impetus behind the Palmer Prize and this lecture series, which is to talk about the tension between national security and civil liberties. Everyone has the right to speak their mind, and we have to be very careful before we impose any kind of rule or regulation that regulates speech or censors it in any way. There are also international legal protections which are corollaries to the American First Amendment, which would apply on the international stage as well and flow from this other body of law, international human rights law. So we wouldn't necessarily, I mean, it's not described as the First Amendment, of course, because that's the way it's rendered in the US legal system, but under international law, all of the major, foundational treaties on human rights recognize a right of free speech. It's usually not interpreted in such an absolute way as the US First Amendment, and it's generally assumed, for example, in European human rights law that governments have a lot more authority to regulate speech when you compare it to the Supreme Court's interpretation of the First Amendment in the United States. Nonetheless, it's undeniable that there are legal constraints on regulating speech, and I take those very seriously. With that in mind, though, is there a room for legal restrictions, or maybe not restrictions, but legal responses to the problem of misinformation? And I think there are, in part because, one, a lot of the major activity in this area is not going to be pursued by the federal government. It's activities and responses that are going to be pursued by the social media platforms themselves. And since they aren't state actors, they have greater authority to regulate than the federal government or a state entity. So even if the federal government wouldn't be able to do something, if Facebook or Twitter want to respond and impose restrictions on some content that's misinformation, they have greater latitude than the federal government. In addition to that, I also think that although the First Amendment protects anonymous speech, which is very important in First Amendment jurisprudence, and also protects false information. You can lie, and the fact that you're lying about something is not per se an argument for why the government can censor it. Nonetheless, truth does matter for the legal analysis, and certainly the whole machinery of defamation and libel and slander is based on a recognition that truth matters, and the legal system will deal with falsehood in a different way. And on top of that, there are avenues that these social media platforms can take which fall short of actually censoring speech. So, for example, you can label a particular set of posts on social media as originating from either a particular location or from an actor who has been tagged with prior activity, which is problematic, and the mere fact that an account or a post has been labeled in some way by a social media firm is not the same thing as preventing that speaker or that account from actually speaking. So all of what we're describing is so far away from anything that could be described as illegal censorship. Even if it was censorship per se, I'm even willing to go so far as to say that I think there is a strong argument that when it comes to protecting an election, that the type of behavior that Russia engaged in would not be protected even under the First Amendment. And by that I mean Russians operating a social media troll farm in Russia designed to influence American political elections, and doing so in a covert way by not announcing themselves as Russians, but describing themselves as Americans. Because, of course, the way the social media disinformation campaign works is they don't say, hey, I'm a Russian person, I'm living in St. Petersburg, this is my view about the candidates in the US election. They plaster their social media page with a lot of American iconography and make it sound like they're someone living in Nevada or someone living in California or someone living in New York, and then they post this content about it, and they try and appear as they're an American. And so I don't think any of that activity would honestly be protected by the First Amendment. The last set of consequences for the legal system are more structural reforms that the U.S. government can undertake. And I think in this regard, the federal government has learned a lot since 2016 and has gotten so much better. But during the election in 2016, there were a lot of mistakes that were made. Just to take a couple of examples, the intelligence community is very much built around a playbook, which is to keep secrets and to look for foreign agents who are in danger of stealing U.S. secrets and disclosing them to either the world or to their foreign government, stealing our nuclear secrets, stealing our military secrets, stealing information that we're trying to keep secret. And so what the intelligence community has historically done is try and recapture that information and put it back in the secrecy box. And then they don't really want to tell anyone what those agents have done, because even to talk about what the agents have done would be to further their aim of getting the secrets out. This situation of election interference is the exact opposite, because what the intelligence community and the federal government should be doing is the opposite. They should be disclosing the foreign activity, because if you disclose the foreign activity, if you say, hey, Russia or some other state is intervening in the election, then people will know about it, and it will disinfect the negative impact that the foreign state is trying to have. It will also allow U.S. voters and U.S. media consumers to be a little bit more skeptical and know, hey, when I'm reading something online, perhaps it's information, perhaps it's homegrown political content, but perhaps it's material that's just been whipped up by a troll farm in some other country. In order for people to have that kind of skeptical view, they need to be told by the government, hey, a foreign agent is actually intervening in this situation. So the entire playbook of the Justice Department Counterintelligence Division needs to move from this old paradigm of trying to keep secrets and move to this new paradigm, which is disclose foreign activity and try and really permeate it to the American population and get the story out. One way to do that is through the use of the use of criminal prosecutions that will talk about these foreign actors, even if the criminal prosecution is unlikely to result in capture, trial, and punishment of the indicted individual. And this is something that the Justice Department, I think, has eventually caught up with through the Mueller investigation. There was a prosecution of the IRA, the Internet Research Agency, which is the entity that created the troll farm. Why go, and not only the IRA, but also individuals who were associated with building this troll farm. Did the Justice Department justifiably believe that they were going to actually capture these individuals, bring them to trial? I mean, there was a couple of corporate defendants who actually litigated part of the case in a U.S. court. But in terms of actual criminal punishment of any of these people, is that likely to occur? No. So why bother indicting anyone? Well, I think the value of the criminal prosecution in that case is that it can serve to get the word out to the public. So the criminal law, which we usually think of as being a legal system simply for convicting and punishing people in accordance with due process, separating the guilty from the innocent before we punish them, that's usually the point of operating a system of criminal justice. But it also has these other consequences, which is it can be an avenue for disclosure of information to the public. And a lot of what we learned about Russian interference in the 2016 election came to the public through the Justice Department's criminal prosecution of some of these entities. So, the public indictment became a form of disclosure to the people. And I think that's a very valuable tool that the government has, and I would encourage the government to use that in the future. So all of this is just to say that we're very much operating, I think, in a new world where there's going to be these threats to not just American democracy, but to other democratic systems. It isn't just Russia who engages in election interference and social media disinformation. A lot of other states are doing it too. They're doing it in part because it's very efficient, and you can get, it's a force multiplier. It's not an expensive activity to engage in. You you build a room like this, you rent a room like this, you get tons of computers, you hire a whole bunch of people who are quite frankly not high-cost employees, they're low-cost employees, and you get people posting stuff, and then you layer on AI bots that will retweet material and amplify content. You can have a huge impact on the international stage for a very small financial investment. And so there's a lot of states out there. Iran is doing it, North Korea, and that's just to name a few small examples. So we're going to see it more and more. And it's also not the first time that countries have intervened in elections. Countries have been doing that for ages, but what's new here is that the way that countries are doing it is very different. And hopefully I've convinced you that international law has a role to play in not just analyzing, but also responding to this new phenomenon. So thank you so much for listening to me. I really appreciate you being here, and I look forward to your questions. Sound good.
So I'm having trouble figuring out how much this all depends on the social media side. So I'm going to throw back some hypotheticals at you. So Roe gets overturned, and there's also some big kerfuffle in the Middle East, in Israel and the occupied territories. And what the Vatican does is every Monday, from starting September 1st until Election Day, it sends to like 80% of the households in the United States pictures of fetuses, right? Except that they fake it, like they're false a little bit, because they make you think it's only 6 weeks old when really it's 20 weeks old, so it looks cuter. You know, there's all
Right.
this information within that, right? But that's what they do. They're sending it, and you're getting it snail mail, and you're getting all of these pictures, right? Deliberately designed to make you vote a certain way, right? And then in addition, some Palestinian organization that's not even necessarily a state, not sure whether that matters, sends all sorts of information to everybody, embellishing a little bit, like painting Israel in a particularly bad way. So it's false, but it is completely traditional information that every U.S. citizen has a First Amendment right to hear, even if the other people don't have a right to say it, right? So would that be the same thing?
Yeah, I mean, I think those are all good questions. I was particularly concerned with social media disinformation in an electoral context. I mean, that's sort of the particular problem I was addressing. And that's not to suggest that's the only problem. And so misinformation generally is a huge problem on social media platforms, even when it's not in the context of an election. And then also misinformation that occurs outside of a social media platform through more traditional modes of communication. Those might be problematic too, although the particular legal framework that I've explored here, I think, is really narrowly tailored to the election context. So it's not to suggest that that other forms of misinformation might be problematic as well, although I think you'd have to conclude for different reasons. But from my perspective, one thing that I think is very relevant for my analysis is not just the social media angle. I mean, that's the factual predicate of my project, but it's not legally a requirement or an element. I mean, I haven't said that the social media content is legally relevant in the sense that if someone managed to have a similar effect through some other mode of communication, that could also be a form of election interference. But let me say what is very much relevant to my analysis, and that is the covert nature of the intervention. So what I found particularly problematic is that the Russians would not only participate in the US election, but they would do so in a way pretending to be Americans and not disclosing their involvement. Contrast this with, for example, a foreign leader who makes a trip to the United States and then gives a speech to a joint session of Congress and says, I don't like this particular policy that you're considering. You should adopt the opposite policy. And here's my reasons for saying you should adopt this other policy. And also, I think you should vote for someone who wants this policy, and here's my reasons why. And you should, avoid this other direction. I have no problem with doing that. I mean, foreign leaders do that all the time. They give press conferences, and it's called diplomacy. And to the extent that even the Vatican is doing that as well, I don't think it's problematic in the same way as I've described, as long as they do it overtly. But when a state, I think, tries to accomplish the same result, but then doesn't stand up and own it and acknowledge that they're the one pursuing this, that's when I think it becomes really problematic. And that's why I think the Foreign Agent Registration Act is a really interesting example of trying to prevent states from acting in that covert manner and make sure that if they do try and influence anything, that it's completely attributable to them.
So, thank you so much for, is this one?
Well, if it's not, I can certainly hear you. You're projecting quite nicely.
Thank you so much for this lecture. I find your analysis really powerful and persuasive. I was very interested in what you said about the sort of interaction between lawyers and then people in these other disciplines, history
Yeah.
and sociology and so forth. And I guess I wanted to ask you about the interaction between international lawyers and domestic constitutional lawyers, and how much dialogue you find between those two different disciplines, and how fruitful you find that to be. One thing that struck me, for example, is that the same kind of argument that you make for why it's a violation of the right to self-determination for Russia to be interfering in our elections. Kind of the mirror image of that is President Trump seeking foreign assistance, both before and after the 2016 election, and that's part of what he was impeached for the first time. And that also could be framed in terms of undermining the American people's ability to engage in self-determination.
Yeah.
So how valuable or common do you find that kind of dialogue between international lawyers and constitutional lawyers?
Yeah, so those are both fascinating questions, and I'll take them as somewhat separate questions, even if though I think their inspiration was the same. So I think that there's not a lot or enough overlap between international lawyers and constitutional lawyers. They tend to operate in separate circles. They tend to talk separate language, even though I think that's not warranted. International lawyers tend to use different sources of law and want to make their arguments using the sources that they're most familiar with. And constitutional lawyers, on the other hand, want to use the arguments and jurisprudence that they're most familiar with. And they're kind of like, independent circles that are sort of spinning without enough relationship to each other. There's also a sense in which that is a very distinctly American phenomenon. So if you go to other countries and you absorb the constitutional law dialogue, it's very much embedded within international law conversations. And there's a integration between them, which is unfamiliar to us Americans. And one of the reasons why there's greater integration in those countries is because they have a monist legal system. And so they see their domestic legal order as being of a piece and participating in the global legal order, and they're just one piece of it. And so there's a practical consequence to that in a lot of European countries. You can go into a domestic court, and while you argue to a judge a particular legal argument citing a constitutional provision or something, you can also cite an international legal rule and achieve vindication for your client and your legal position. Well, except in very rare cases where international law is specifically relevant to a legal case, if you're an American lawyer and you walk into a legal, into a court representing a client, and you just cite a whole bunch of international law, the judge is usually going to look at you and say, okay, but this is America. What does this have to do with, the international legal system? Can you tie it to a particular statute or to a rule in the U.S. Constitution? And unless international law has been incorporated into the U.S. legal system in some way, I don't really want to hear it. And so that's our dualistic legal order. And I think that's very much one of the reasons why U.S. law, constitutional law, and international law are often kept separate and apart. So I can understand why lawyers are trained that way. Now, on this second question you had about solicitation of foreign involvement, I do end my book with a discussion of solicitation, and I wrote it, at the time when the impeachment was ongoing and Congress was, deciding what to do and how to, assess Trump's phone call with Zelensky and whether or not this was problematic. I suggest in the book that it was, it was wrong for Trump to have done that, and it was certainly within Congress's authority to declare that an impeachable set of, of conduct. Whether it violated an existing federal statute, I think, is a little bit complicated. And I end my book by saying, maybe it is, maybe it isn't. I don't want to suggest one way or the other. But to remove all doubt, it would be a good idea for Congress to pass a new statute explicitly declaring that individual solicitation of a foreign government's involvement in one of our elections is a new federal crime, to remove any doubt about whether or not an existing statute covers it, and therefore in the future, if it were to occur again, the federal government could prosecute that situation. Now, like all lawyers, we are often in a situation where we're regulating tomorrow based on crises which have happened in the past, but nonetheless, that's what we often are forced to do. That's the direction of time.
Thank you. And Mark, I think we'll have time for one more question.
That's great, Anita. Thank you.
So I'm also very persuaded by your presentation, but it brings a question to my mind. So you're talking about self-determination. I want to think about how that works in conjunction with democracy in this sense. So one tenet of democracy is that people who are affected by a policy's decisions ought to have some say. We're concerned about externalities.
Yes.
Okay. And so I could understand. So your argument from self-determination leans very heavily on citizenship, and I wondered what, if any, room you think non-Americans or outsiders appropriately actually play in another country's political system in a circumstance where that country can have substantial impact on the outsider. And so in thinking about this, it would perhaps be useful to put aside disinformation, which we can all agree is bad, although perhaps Russians cloaking themselves as Americans are a response in part to the idea that complete outsiders have no role to play.
Yeah.
But I guess the question is, yes, 3 cheers for self-determination, but what about externalities and outsiders?
Yeah. Incredibly relevant question. And if you, I don't think lawyers tend to grapple with this question rather well, but if you read the political theory literature on democracy and voting rights, they very much grapple with this issue, and there are political theorists out there who have argued this point and suggested that if you're a citizen in a faraway country that's being impacted by American power, why don't you have the right to participate in a U.S. election? Because your fate is very much being determined by what American political leaders are doing. You're on the receiving end. I'm not just talking about military force. That's the most obvious example. But whether it's diplomatic or economic power, that individual is often living or dying based on those decisions. Doesn't that give them a right to participate in the U.S. election system? And so that argument is there in the political theory literature. The two things I would say about it is, and this is kind of the lawyer in me coming out, if we accept this argument, I don't see how we really integrate it with a classic understanding of democracy and self-determination and draw any set of workable lines in terms of who can participate and who can't. Because quite frankly, there are people all over the world who are impacted by U.S. power, and the same thing with Russian power and Chinese power. I mean, they don't have democracies in the same way, but if you don't want to use them as examples, think about Britain. I mean, the British Empire is, casts a long and dark shadow over the entire world, and so there would be people all over the globe who would have, under that argument, a right to participate in a British election. I don't see any way of managing and controlling that in a principled way, and it seems like the engine of democracy at that point and elections would collapse. The one thing, though, that I would say is, as a lawyer, how then do we respond to this point about externalities? Because the conceptual point that you've made remains. You've got these externalities, and you've got these people who are impacted by our power and have no right to participation. And what I think the political theorists who make this argument don't fully appreciate is it is not the job of democracy and elections to manage those externalities and mitigate those externalities. That is precisely what international law is for. So to the extent that there are externalities imposed on those innocent populations who don't have a right to participate in our elections but are impacted by our decisions, the norms of international law and the international legal system, if they're operating correctly, that machinery, international law, is what hopefully forces states to treat each other humanely and to take into account the interests of peoples elsewhere. Now, of course, it doesn't always, and international law is an imperfect system, and human rights only goes so far. But in theory, the branch of law that should be dealing with those externalities, the problem of externalities, is the international legal system.
Thank you so much. Please join me in thanking the
Thank you.